Boy, this is going to be a tough question.
How will my retirement account be
Consultant
affected?
specialist filing for bankruptcy.
George, good evening. Go ahead.
What are some heat pump
My identity
advantages?
is installed.
Good evening and welcome to Ask an Expert, WNIT's live program where we give you a chance to call in and go right to the source to get your questions answered. I'm your host, Gary Sieber. Good evening. Tonight, we'll be taking your questions about family law, bankruptcy law, and criminal defense. In a shrinking economy, foreclosures and personal bankruptcies are on the rise. So what happens if you find yourself in that situation? Do you lose everything but the shirt on your back? And what should you do if you find yourself charged perhaps with drunk driving? If you're going through a divorce, what steps do you have to follow to collect child support? Our panel of experts tonight can help you with those questions and many others. And here's our legal disclaimer for the night. Keep in mind that any advice given here tonight is no substitute for one-on-one legal counsel, and we recommend that you seek appropriate help with your own individual circumstances. Having said that, joining us in the studio tonight are James Tamke. Jim was admitted to the Indiana Bar Association in 1985 and the United States Tax Court in 1990. His areas of expertise are bankruptcy and tax law with 20 years in private practice experience in South Bend. Beverly Peters, a family law and adoption attorney, has 15 years experience right here in the city of Elkhart. Since 1994, Peters has been a member of the Elkhart City Bar Association, the Indiana State Bar, and has served as a member of the Family Law and Juvenile Division. Todd Walsmith of Nichols & Walsmith in Knox, down in Stark County, he's here to talk with us about criminal defense. Todd has been a member of the Indiana Bar Association since 1997. For 5 years, Walsmith served as Deputy Prosecuting Attorney for Stark County. Welcome to the program. Thanks for sharing your expertise and your time with us tonight. We appreciate it, and we invite all of you at home to join the conversation tonight. And it's very easy to do. You simply call the number that you see on the screen if you have a question for our panel of legal experts. Where else can you get free legal advice, after all? Speaking of numbers, though, last year 2 million people declared personal bankruptcy. Jim, you probably see a trend continuing, I would think, in 2009. And the first thing that happens when you get in that situation, many people fear, is they lose everything they own. And maybe you can dispel that myth for us. What happens when you end up in bankruptcy court?
Well, actually, Gary, the truth is most people don't lose anything because of exemptions that allow them to keep their property. And most people that file bankruptcy have enough exemptions to keep their property. There are certain debtors that have non-exempt property, but then they go into Chapter 13 and pay a certain amount into their unsecured creditors over a period of up to 5 years that allows them to keep all their property, even though they don't have enough exemptions.
Yeah. There are probably people out there who maybe, I don't want to say on the other side of the fence, but who look at bankruptcy law and say, oh, that's a cop-out. You know, this is an easy way for people to get out from debt. It maybe is not as easy as some people may have the illusion that it is, but it doesn't take everything away either. Is that right?
Well, that's true. It's not as easy as people would think. Under the new bankruptcy law that came into play in 2005, there is now means testing where they have to prove that they don't have the income to pay these debts. And it's ironic that the illusion before the new bankruptcy law was that people were filing bankruptcy when they didn't have to. Now the means testing has proved that there's at least as many people filing now as were before the new law. So, and they do get to keep most of their property, as I mentioned.
And with the economy shrinking, are you actually seeing the numbers go up? We read in the headlines all the time that that's the case. Is that what you're seeing in your experience?
We're seeing a lot of that. I started my practice doing 50% tax law and 50% bankruptcy. Now I'm doing about 90% bankruptcy.
Wow.
And we brought on another attorney into our office this past year where she does nothing but 100% bankruptcy.
Well, sign of the times. Bev, I can't think of anything more painful than families going through divorce, especially when children are involved. You see this every day. Does it ever get to you to the point where, you know, it's every day you must see this kind of family pain going on? But yet you provide a service in all of that.
Yes, it is difficult, emotionally difficult and draining on the families. We hope that we can provide a positive service for them. Elkhart County, St. Joe County is moving really into kind of a paradigm shift in family law, where when children are involved, the goal is how do we best solve this problem, rather than how do you beat up the other guy. So family law is in evolution and real positive changes emotionally for the people involved.
Divorce lawyers, so to speak, have been so lampooned over the years in the media and sitcoms and other kinds of things.
true.
Do you run into that all the time? And if so, how do you work with people who are on the other sides of maybe the lawyers who represent the other party in a divorce situation, for example?
Well, again, we're undergoing some changes. There are local rules that attorneys have to follow. And Elkhart County, for instance, is in the process of drafting some rules where it makes it a kinder, gentler place to practice law and really looks down on the lampooning, if you will.
Sure. What's the first step that someone should take if they're in that situation where they know, this is something that I definitely want to do, I definitely want to seek a divorce? Is the first step to call a lawyer, or should they be doing something else to put things in order?
Well, I think certainly they need to make sure that's exactly what they want to do. Sometimes counseling is in order, family counseling or marriage therapy before calling a lawyer. But once you're absolutely sure, yes, call a lawyer. There's mediation services. One attorney cannot represent both parties. But you question your lawyer about their philosophy, etc., and you hope that attorney, or you can find an attorney that meets the same kind of goals that you have in the divorce process.
Again, if you want to participate tonight, call the numbers on your screen, and our experts will be taking your calls and trying to answer your questions as best they can. Todd, in the area of criminal law, let me start with a philosophical question. There are those out there who say, how can you do what you do? How can you represent someone who you might think, or might even know, committed a crime? They deserve legal representation, after all, but that's one of the most common questions I think I hear about defense attorneys.
It's a very common question, and coming from a prosecutor's office, it's one that I had to deal with personally. And what I found is this: people everywhere make mistakes. Some people make mistakes that fall into the area of being criminal. Others may fall into mistakes that end them up in a divorce court. An attorney's job in the end, no matter whether it's a criminal defense attorney, a family law attorney, or even a bankruptcy attorney, is really being there to help another person with the mistake they've made. As far as how I can do it, I have helped more people, actually in their personal lives, that were criminal defendants than I ever did as a prosecutor. I try to provide information to my clients about substance abuse counseling, even psychological help in many cases. You'll find that in Indiana, a large number of people that are imprisoned are actually suffering from mental illness, usually undisclosed or undiagnosed. And unless somebody knows to really direct a defendant there, they may not ever get the help they need. So I've actually been, I think, of more service to my clients as a defense attorney than I ever was to a defendant as a prosecutor. I have clients that are now sober for 5, 6, 7 years, and I would just wonder how long that would have continued if they hadn't gotten the help from professionals that they were able to get. So
it's kind of a side of your profession that we don't hear quite so much about. Our program tonight is, after all, about the calls and the questions that you have, and let's get right to the phones if we can and get started. John is on the line from Granger with a question about bankruptcy and specifically how it relates to student loans. John, good evening. Go ahead with your question.
Hello. Thanks for taking my call.
Sure.
My son filed bankruptcy, and they got a judgment from the federal judge, and it even declared that the student loans were in the bankruptcy, and it was the only reason that he filed. And he was young when he went down to Florida to go to school, and these predatory lenders took advantage of him, and I wasn't even aware of it. And then he makes about $10 or $11 an hour gross. He can't even support himself, and now they've attached his taxes, and they guarantee his wages. And you talk to a lawyer, and they run like a coward. They say, you can't file on a student loan. Now, looking in the world economy today, who's bailing out the banks? They're crooks. So I would like to ask you, would you take a case like this?
All right, John, thanks for the question. We appreciate it. Jim, let's turn to you as a bankruptcy expert. These are very difficult cases, and you could sense, I mean, there's the anger there in John's voice, not only about his son's case, but about the state of the economy in general.
Yes, and we hear that every day, Gary. In regards to the student loan question, student loans are generally non-dischargeable in bankruptcy. However, clients sometimes get a little bit confused about that because the law says that you have to list all of your debts, whether they're dischargeable or not. Now, under certain circumstances, a student loan can be discharged, but the attorney for John's son would have had to file what's called an adversary proceeding and serve it on the student loan lender as well as the guarantor through the United States Attorney's Office. It's something that happens very rarely. The law says that you have to prove an undue hardship. Well, everybody that files bankruptcy has a hardship, and what makes it difficult to discharge student loans is that student loan lenders often will put somebody in what they call forbearance, which means that they don't actively pursue the loan. Now, in John's son's case, they are pursuing it, so he might want to consider going back into reopening his case and filing that adversary proceeding, because some of them do get determined to be non-dischargeable.
Is there a time limit on that, that you have to file by a certain date? In other words, can he go back now and do that after the fact, so to speak?
There are time limitations. John, when did your son file bankruptcy?
I don't think he's still on the line. So
yeah, when it gets beyond 1 year, it's pretty hard to do. But
okay.
He might want to consult with his attorney and see what his options are.
All right, and one last thing, Jim. When you talk about things, and I'll try to do this as the night goes along,
sure.
We talk about things like dischargeable or non-dischargeable, and you talked about forbearance, for example. Explain some of those terms. John probably is not a lawyer, I'm not, and I'm thinking, what does that mean when you say generally student loans are non-dischargeable?
Yeah, what that means is credit cards and medical bills are considered to be dischargeable, which means that you don't have to pay it anymore. You don't owe the debt anymore after you've received it.
You're relieved of that.
You're completely relieved of that debt. There are certain other debts, including student loans, child support, for example, that have to be listed in the bankruptcy, but they continue to be owed even after the bankruptcy is filed. Now, we've even had, it's not unusual for someone to file bankruptcy when none of their debts are dischargeable. For example, to stop a foreclosure, people will file a Chapter 13 bankruptcy, which will prevent the sheriff's sale from going through and allow them to keep their house, give them up to 5 years to catch up the amount they're behind on their house, and they're not even attempting to get a discharge. There is something now called a no discharge Chapter 13, which is being used more and more during this mortgage crisis.
Mm-hmm. We hear a lot of things in the news about Chapter 13, Chapter 7, Chapter 11. We'll maybe come back to that at some point during the show and clarify what those are. But one last thing, John mentioned that he felt that his son had been victimized by predatory lenders down in Florida. Does that enter into this at all, or would he have to pursue something entirely separate from that if he wanted to, let's say, go after that? Or does that matter in bankruptcy court, what kind of debt that you have in terms of student loans?
Well, I think it does matter, and we're seeing more and more of that also. In fact, there's a new term called monster debt, where companies are buying up debts that have been discharged in bankruptcy and then calling credit bureaus and listing them on someone's credit report. And then when someone goes to refinance a house or purchase a house, they get a call from a title company saying that there's a debt for $100, $200, $500, $1,000. And in a lot of cases, the person will go ahead and pay that debt even though it's not owed, just so that they can get the financing. So there's a lot of that out there, and there are serious penalties involved. But the creditors that are doing this are making so much money off of that even when they pay the penalties, they seem to profit.
All right, Jim, and again, we'll come back to Chapter 13 and all that in just a little bit. Meantime, George is on the line with us now from Warsaw. George, you're over 65 or disabled. You say, do you have to pay debts? Is that true? Go ahead with your question.
Article in Senior Life, and you're supposed to call DCSD They got 800 number, and they claim that after you're 65 or disabled, that you don't have to pay your credit card debts. They'll be cleared.
All right. Let's see. And are you talking about in bankruptcy court? Are you still on the line with us?
No, just clear your credit card debts.
Okay. If you're over 65 or disabled, Jim?
Thank you, George, for your question. Actually, there is no law that says that you don't have to pay it when you're over 65. I think what George may be referring to is the fact that a lot of our senior citizens are on Social Security, and creditors are not allowed to take their Social Security, and therefore they're considered what we call judgment proof. But even though Social Security is not allowed to be taken by creditors, once that Social Security is deposited in someone's bank account, the creditor can still take that if they have a judgment through a lawsuit.
Okay. All right. So a little bit different question there. Let's come back just for a second to Chapter 13, and not at the risk of monopolizing the discussion here in terms of bankruptcy court and that sort of thing. Tell us a little bit about that. You mentioned Chapter 13. There's one that's reorganization. There's one that's different from that. Which is which, and which apply to personal bankruptcies?
Actually, both of them apply to personal bankruptcies. Chapter 7 is sometimes referred to as a complete bankruptcy, Chapter 13 as a payment plan. There are several forces that may drive one to go through one or the other chapters. There seems to be a preference for Chapter 7 because people want to get a fresh start and get on with their life. However, in some cases, Chapter 13 can give them a better deal because there are certain remedies available in Chapter 13 that are not available in Chapter 7. For example, something called the cram down, which means that in Chapter 13 you only have to pay, in most cases, the value of your personal property, and you can adjust that interest rate downward, whereas in Chapter 7, if you want to keep an automobile, you have to do something called a reaffirmation, which means that you agree to pay the contract rate of interest and the payment that was agreed on in the original contract. Now, in Congress right now, there's legislation pending that President Obama has indicated that he would sign that would allow people to do this so-called cram down on their personal residences, and that would probably go a long way towards solving the mortgage and housing crisis right now, because under current bankruptcy law, you cannot do this cram down on residential real estate.
Okay. All right. And again, this is one way of addressing the foreclosure issue that we've had and seen such a problem with here over the last year or so. Bev, let me turn to you for just a second in terms of family law. And I know we're going to get a lot of calls tonight on bankruptcy. I think that's fairly clear here. But you mentioned that laws changing in the state of Indiana and really trying to think in terms of divorce law as what's to the best benefit of the children that are involved. And so often we hear about those cases whenever there's a divorce, it's bad, but when there's children, it's magnified, much greater than that. What are those laws like, and how are we working now to make sure that children are really thought of in a little bit more high regard by the courts as we go through these proceedings?
Okay. What I was referring to really is how we frame family law and how we as attorneys deal with that process. There are some local rules that attorneys follow, but what we're looking at is keeping the parties amicable. Mm-hmm. We believe that, and studies show, that other than death of a parent, the next thing that adversely affects a child is a divorce situation. Mm-hmm. Studies show that they need the most input from both parents. And if we can keep the parents on the same page, if you will, most parents agree at least on one thing, and that is that they love their children, they want their children to thrive. In the old paradigm, it was difficult to keep focused on that. Mm-hmm. And the arguing, the conflict, you would see behaviors in children and et cetera. So sure. As attorneys, we're attempting to handle this differently.
All right. Mm-hmm. Let's go back to the phones now, and Cindy is on the line from Vandalia, Michigan. Cindy, good evening. You've got a question as well about bankruptcy. Go ahead with your question.
Thank you. Good evening. In September of last year, we had filed bankruptcy in 2004, and in September of last year, my husband got pulled over for a traffic stop. There was a warrant issued for him for a failure to appear for one of the creditors that we had, and he was taken to jail. The next day, the attorney got him out. We had to get a paper signed from a judge to get him out of jail. What I'm concerned about is he missed work, I missed work. He got a point against him. We had our truck towed in. Is there any legal recourse that I can personally do to go to the bankruptcy court and try to get reimbursed back for that?
Okay. Well, let's turn first to Jim. There may even be a criminal aspect to this. I'm not sure. But go ahead, Jim.
Yes, Cindy. First, you'll want to contact your bankruptcy attorney and ask him to look into the possibility of filing a contempt citation against this creditor for violating the permanent injunction that is received through the discharge order in bankruptcy. That could entitle you to some potential punitive damages, in addition to the damages for taking time off of work.
And that sounds, like there's some recourse then for Cindy in this case. Talk about that a little bit. When you talk about punitive damages, that's beyond just being compensated for your time. That's basically damages or an award that would be intended to send a message to others similar kinds of organizations that they can't do that, right?
Well, that's correct, Gary. And about 10 years ago, Sears and Roebuck was hit with about $50 million of damages for violating the what's called the automatic stay, which is like a temporary restraining order until someone gets the permanent injunction. And a lot of those damages were punitive. The whole idea is to deter them from this type of behavior.
All right, so one more time then for Cindy, in case she missed that first part. She needs to get back in touch with her bankruptcy attorney and ask for what?
Ask him to consider reopening the case in the bankruptcy court and filing a motion for what's called a contempt citation for the violation of the discharge order of the bankruptcy, which is a permanent injunction against the creditor taking any action to collect your debt. And this will definitely come under any action.
All right, well, they're very good. That should help Cindy quite a bit. Todd, was there any, I don't know if there was any sort of criminal aspect to that or not. Could you hear anything in there that...
Other than the fact that there was a traffic violation, not really criminal, but I think it's important to point out that in Indiana, and I know she was from Michigan, but in Indiana you have two kinds of warrants. You have those warrants are issued in a criminal case. Those are usually based upon a judge's finding a probable cause that a person has committed a crime, or they're issued when a person fails to appear for a court date in a criminal case. But there are also circumstances in a civil case after actually a rule to show cause or contempt citation has been filed, in which a person fails to appear for court, and then a judge will issue a body attachment, another name for a warrant. It orders a sheriff or other law enforcement officer to arrest the person and hold them either for a set amount of bond or until they can be brought before the judge. And of course, the same things happen from time to time in family law cases. Although a lot of times the sentences in those cases are stayed, or the court will give a defendant or a party to a divorce the opportunity to purge themselves of the contempt, right?
It's often used for non-payment of support, and the bond set would be equal to the amount of support owed.
And Bev, while we're on that topic, let me follow up on that too, because if someone is going through a situation where they're trying to collect child support, and we hear a lot about this, there are prosecutors, for example, who have made big efforts to make sure that they're collecting those tax support. What's the main thing that people need to do to make sure that they can collect those? Is there a particular set of steps that they need to follow?
What I would say tonight, based on the economy, is that if a person has lost their job, they need to go into court immediately and ask for a modification of support. That won't happen, and the court won't do that retroactively. So they need to get into court and ask for that modification right away. And again, in collecting support, same thing. You need to file a petition and ask that they repay the arrearage, whatever that may be.
But don't wait, that's the key.
That's really the key, yes.
All right. Back to the phones we go. Bobby's on the line from Rochester, and unfortunately has had the experience of being laid off from your RV job. Bobby, good evening, and go ahead with your question.
Yeah, I'm a laid-off RV worker. I was laid off from Monaco, and I was forced to file bankruptcy in August of 2008, and the trustee would not discharge the debt until I filed 2008 tax returns. And I was just wondering, I have 3 kids, I lost my home, lost my vehicle, and I'm still unemployed. And I wonder if there's any recourse of action I could take or any motion I could file with the trustee to try and keep my tax returns rather than have them distributed.
Okay. Here we go again, Jim. This question for you.
Well, thank you, Bobby, for your question. Unfortunately, you're not going to like the answer. Tax refunds do not come under those exemptions that I mentioned. So tax refund is nothing more than a savings account that people have set up with what I call the IRS bank. And then there's a limitation on savings accounts of up to $300 can be exempted in bankruptcy. Everything else would go to the trustee. Now, there is one exception to that. And if you have an earned income credit, the trustee cannot take that. So you may want to take a look at your return. And if your preparer claimed what's known as an earned income credit, that part of your refund you can keep.
And earned income credits are based on the income that you have, and is it also based on children, or what else is involved?
Yes, for the most part, based on children and the amount of income.
Okay, and you would know that by looking at your previous year's tax return to find out if that was part of what you did.
Yeah, they would know it, but I'm always amazed when I ask somebody, they're not sure and they have to show me the tax return, and I'll look at it and point to the line and say, yeah, there it is. You had a $3,000 refund, $2,500 was earned income credit. You get to keep the $2,500, and the other $500, the trustee's probably going to look the other way on and say, keep the whole thing.
So it sounds like then for Bobby, again, the best thing he might want to do is get back in touch with a bankruptcy lawyer and go through the last year's tax return and find out if, in fact, any of the refund that he got was from an earned income tax.
Yes,
credit.
exactly. However, the trustees are pretty well versed in that, and they'll generally catch it when the client's attorney does not catch it.
Okay. I would assume, Jim, that you're hearing more and more of this, especially in our area, as we have people who are in that same unfortunate position that Bobby is, where they've lost a job, in many cases in the RV industry, but a lot of other industries are affected as well.
Yes, it's just kind of a trickle-down effect, and we do see a lot of people from the RV industry and other industries as well. And what's interesting is not only are we seeing the actual workers from these companies, but we're having some of the owners come in and talk to us about filing bankruptcy.
I can certainly believe that. And we hear a lot in the news. We mentioned Chapter 13 and Chapter 7 earlier. We hear a lot about Chapter 11 in the case of businesses, which also is a reorganization step, isn't it?
Well, that's correct. Chapter 11 is for corporations to reorganize and stay in business, because when a corporation files a Chapter 7, which it can do, it will go out of business. It will have to go out of business and get liquidated, and creditors are paid from the proceeds of the assets that are sold. But they can go into Chapter 11 as a corporation and restructure their debts and stay in business. And I might mention that a corporation cannot do Chapter 13, so they will have to look to Chapter 11 if they want to stay in business and get debt relief.
Continue to function and reorganize their debts and that sort of thing.
Yes.
All right. Todd, we often hear that in a bad economy that crime increases. That's sort of the myth anyway. Is there any truth to that, or are you seeing an increase in the amount of criminal activity that's going on right now, or does it pretty much stay the same, or does it even decline actually when times get worse?
I don't have any statistics, Gary, but the one thing that I've noticed, and I think a lot of people have in the papers, the number of burglaries have gone up, the number of shoplifting charges have gone up, the number of thefts have gone up. I haven't noticed an increase in a lot of the substance abuse crimes or the juvenile crimes that you normally see. But if I had to guess, I would say that probably overall the thefts, burglaries, and robberies will go up a little bit. Robberies probably a little bit less, because the thing that people need to keep in mind is that a lot of these people that are committing these, the new crimes especially, they weren't criminals before. Yeah. They're driven by desperation. And violence isn't something that may come naturally to them, but I would say that you'll see burglaries. The other thing is, of course, you see a lot of theft of metals and scrap materials.
Scrapping. And that may even decline right now, because the prices for that are so low. Before they were so high, but right now the amount that you can get seems to have come down quite a bit. That may have driven that down just a bit, I would think. Meth and drug trafficking is the other one that you see a lot of, especially right now.
And meth, Methamphetamine, and I have seen in surrounding counties, is a common thing in the paper. Stark County became aware of the problem for the first time in probably '98, and a concerted effort was taken at that time. Since probably 2001, 2002, the state police with their clandestine drug labs, the Stark County Sheriff's Department, Knox City Police, the other departments in Stark County have done a pretty good job of reducing the number of active meth labs in Stark County. Again, methamphetamine is a drug that is not going to be impacted, in my opinion, by the economy. It's typically people who are looking to escape from reality, which is much worse than just not having money. Yeah. So the need that these people feel to use controlled substances isn't likely to change. It's going to be there, and it's just a question of how much methamphetamine is available or how much marijuana is available. It is not something that we're going to see in the numbers we did, say, 4 years ago. Yeah. I think methamphetamine's on the way down for a while now.
Okay. Well, we'll have to see about that one. Ron's on the line with us from Warsaw. This sounds like a question that'll probably be for Bev. A question, Ron, about a recent divorce. Go ahead.
Yes. My wife recently filed for divorce, and I've talked to my attorney about getting 50-50 custody. He tells me that since my wife was a stay-at-home mom of our 3- and 5-year-old, even though she works full-time now, my chances of getting 50-50 are very slim. What can I do to increase my chances?
Okay, Bev?
The judge will look at a number of factors. Certainly who was the primary caregiver is a big factor. How much time the child spent with each parent is a big factor. I will say that it is much easier to get 50-50 or at least increased parenting time over standard parenting time than it used to be. And again, that's the studies show that children do best when they have the most access to both parents. Specifically, what you could do, maintain a stable residence, have a bedroom for the kids, stay current in support, just basically be a good parent. You certainly don't want to get in a situation where the judge is going to determine that you and the wife can't get along. One of the prerequisites for joint legal custody is that the parents can communicate. So those are just some of the things that you can do. I would like to know, I guess, some more facts about the situation as far as what kind of situation the wife is in and what his situation is.
Because those factors would certainly affect it.
Multiple factors
yeah.
that the judge looks at. He looks at the prior relationship, he looks at the health of both parents, mental illness, criminal history, many factors. That.
But you did mention some things there that he could do to kind of at least increase the chances of seeing something like that. You mentioned that the judge would have to make a determination of who's the primary caregiver. Define that for us a little bit. How does that work, and what criteria are used to determine?
In the telephone question, that relates to who was the primary caregiver at the time. And that means who changed the diapers, who fed, who got up at night, who gave them their bottle, etc. And that's just important because a very strong bond forms.
Yeah, I'm sensing too that whatever bitter feelings there might be between the two parties, it would be important for him to, as much as possible, try to let that go to establish the kind of track record that you're looking for that would increase the chances of that 50-50.
Absolutely,
right?
Absolutely, yes.
Okay.
It's difficult to do, much easier said than done.
Very well said. Rhonda's on the line from South Bend. Rhonda, another bankruptcy question I sense. Go ahead with your question. Good evening.
Hi, Gary. Good evening to you, too. I'm self-employed. I own my own business. It's considered an LLC. When I file my taxes, it's it states just my personal name and my social security number. The IRS has levied a bank account that no longer exists, so I'm not too sure if it was a personal or business account that got levied. They didn't disclose what account other than the name of the bank. I don't any longer have a personal account. Can they levy my business account?
And hang on the line if I can. Is she already gone? I was going to say, if you can hang on the line for a second, sometimes there's a follow-up question. But Jim, go ahead from what you could determine there.
Yes, from the facts as I understand them, if she filed personal and her LLC did not file bankruptcy, then they would be entitled to levy on her LLC, because that's a separate entity and that would have to file a separate bankruptcy, either Chapter 7 or Chapter 11.
Okay, let's see if I understand this now, because I get lost in all the alphabet soup. LLC is a limited liability corporation company?
Yes.
All right, and what does that afford you? If you run a business, let's say, and she said, Rhonda there said that she runs her own business as an LLC, what protection, if any, does that afford you when you get into a situation like that?
You mean to have an LLC?
Yes.
Because Ron?
Well, actually, if you have assets that are in the LLC, equipment, vehicles, and so forth, then generally they stay in the LLC. I would add that the ownership of the LLC is an asset of the personal bankruptcy, and I'm assuming she probably owns 50 or 100% of that. So the bankruptcy trustee and her personal bankruptcy can put a value on that business. But normally what happens is that even though the LLC has its own assets, they also have their own debts. And by the time you subtract the debts, there is no value to it, and therefore she would be allowed to keep the LLC in business.
Okay, but in this case you're saying, and going back to the original question about levying the bank account, it sounds like they can proceed that way, is that right?
Yes, oftentimes some creditor will have a judgment against the LLC, and then the owner of the LLC made a personal guarantee. So what will happen is that when the individual files a personal bankruptcy, that will protect them in that the creditor cannot pursue them personally. But with the judgment against the LLC, that's not stopped by the filing of the personal bankruptcy, and they can levy on they can attach that bank account of the LLC.
Okay. This gets pretty complicated, doesn't it?
It gets very complicated.
And it really does depend on each individual circumstance. And again, we want to point out that even though we're trying to help with the questions that you have here tonight, you do want to seek some personal legal advice in some of these cases, because it really does come down to the individual circumstances. And we heard that a moment ago as well in family law, because there would have been certainly follow-up questions that you would have, Bev, about the way and the circumstances and the track record that each of these individuals has in terms of child custody cases, right?
Absolutely.
Yeah.
Yeah.
And Todd, from a criminal standpoint, we're kind of talking about civil cases here and bankruptcy cases, but we talk about track record. I assume that that's something that all judges take into consideration, regardless of what they're involved in. They're always looking at sort of a pattern of behavior, aren't they?
They do. The thing is a lot of times judges aren't privy to all the criminal history information that's out there. In Indiana, there are basically 3 types of criminal offenses. There are misdemeanors, felonies, and then what we call quasi-criminal, which is infractions such as traffic tickets. In the case of a felony, a court, if it's going to sentence somebody, is going to have a pre-sentence investigation done, which will summarize a person's life, family, job, education, mental health history, and prior criminal history. And when there's a long prior criminal history, it's hard to get a satisfactory sentence for a defendant.
Mm-hmm. A lot of times in reporting, we hear in the media, for example, we'll hear that somebody was picked up for DUI or DWI or OWI. I saw that one the other day. We tend to think of them as being all the same, I guess, when we see them on the news. But what's the difference? What do people need to know about those?
Well, in Indiana, there is OVWI. That's operating a vehicle while intoxicated. DUI, driving under the influence, DWI, driving while intoxicated, are all either terms used in other states or adopted by the media or somebody else reporting it to put a face on it that you can recognize. In Indiana, there are basically 4 misdemeanor offenses. There's operating over 0.15 BAC. There's operating over 0.08 BAC.
Blood alcohol content, right?
Correct, blood alcohol content. There's operating a vehicle while intoxicated, and then there's operating a vehicle while intoxicated endangering a person. A person could commit all 4 of those at one time, and because of the way our criminal law system works, you could only be sentenced for one of them. And they are the operating over 0.08 blood alcohol content and the operating while intoxicated are both Class C misdemeanors. They carry a maximum sentence of 60 days. The operating over 0.15 BAC and the operating a vehicle while intoxicated endangering a person are both Class A misdemeanors. They carry up to 1 year in jail. Additionally, if you had a second offense of any of those within 5 years of a conviction for one of those, the second offense would be a felony and would be punishable by 6 months to 3 years in prison.
And when you're defending someone who has been charged with one of these, are you first looking at whether it's a first offense, and if so, are you going to approach that case in an entirely different way?
I do. On some levels, I approach it in a much different way. The first thing that I want to know is what actually happened. And that's the one advantage as a defense attorney that I have over the state and the prosecutor. I get to talk to a defendant, and they can tell me what happened. I can't tell anybody. It's all between myself and my client. But then I know how to defend the case. And I take a 2-step approach to every case, which is on one hand, we prepare for a sentencing hearing or a plea agreement. And on the other hand, we prepare to fight the case at a jury trial or through a motion to suppress. The reason is 90 to 95% of all operating a vehicle while intoxicated cases charged in the state of Indiana, with the exception of a few counties that don't pursue them as strongly as others, are going to result in a conviction. Somewhere, I would say most counties are 1 in 10 or 1 in 20 are not going to result in a conviction for operating while intoxicated. That being said, a good attorney might be 15% success rate, getting something other than operating while intoxicated. The key is knowing how to get somebody who has committed the offense, who is likely to be found guilty, into a position where a judge can say, and a prosecutor can say, look, instead of an operating while intoxicated that's going to result in a driver's license suspension, we'll give you a reckless driving. How do you get to that point? And the best advice I can give everybody out there is first, talk to an attorney. DUI, as they call it, OVWI, is not something that you want to go into without an attorney's advice. You can lose your license for a long time, up to 10 years. You can lose your job, and this is people don't realize, if you get on operating while intoxicated and you are operating a company vehicle at work, not to say that you got it while you were at work, but you get an OVWI on Friday night, Monday you go to court, you plead guilty, Tuesday you go back to work, you're driving a company vehicle. As soon as the insurance company for your employer finds out that you've got an OVWI, they're very likely to refuse to insure you any further. And suddenly your employer has an employee that can't drive the vehicles, can't do what they need.
And you may be out of a job then too.
I see it very often. So the best advice is, if you get arrested for operating while intoxicated, talk to an attorney.
All right. And beyond that, the best advice is please don't put yourself in that situation. I mean, that goes without saying. Nancy's on the line from Elkhart with a question about grandparents' rights. Good evening, Nancy. Go ahead.
Hello. I had a question for Bev or whomever could answer it or so. What is in the state of Indiana regarding grandparent rights? I have a grandson that is, the couple is not married, but did not know what we...
There is a statute in Indiana that addresses grandparent visitation, and it's applicable in limited situations. The first of which, sounds like the caller had this situation, where the parties do not marry, child's out of wedlock, but paternity has been established. If paternity has been established, then the paternal grandparents can petition for visitation. In a situation where the parties have been married or not, but one of the parents is deceased, grandparent can petition for visitation. And third, in a divorce situation. Now, again, as we said regarding joint legal custody, it's very important that the grandparent visitation does not create conflict in the underlying living situation. The U.S. Supreme Court has said that absent abuse, parents' rights trump grandparents' rights. But we also recognize that visitation for grandparents and for the grandchild is important.
Yeah.
Social value.
And it's unfortunate. Nancy, we apologize. We didn't get the end of your question there to learn all of the circumstances there, but it does sound like the first situation that you described is probably the one that would apply, which is if you have an unmarried couple and paternity's been established, if Nancy's in that situation as a grandparent, it sounds like she could at least request visitations and would have some rights, and hopefully some legal recourse to establish that. But it sounds like the key is you've got to have at least a decent relationship with perhaps the mother there, huh?
Yes, and it's often when it's ordered, it is limited. It just, again, depends on the situation, but you can imagine mom has one weekend, dad has another weekend, and grandparents are asking for the third weekend. So sometimes the judge will order that grandparent visitation take place during, if they're the maternal grandparent, during the weekend that mother has the children. So that's kind of a shared time.
Okay. Well, it does sound like Nancy at least has some recourse, though, and she might be able to pursue, just depending on the rest of the circumstances there.
Yes.
That's good. Bev, while we're on topic of family law, let me ask you about adoption, too, because I noticed that's in your resume. I see a lot of people, who have been trying to adopt children. They have maybe some luck in the United States. A lot of people are going overseas. I'm aware of at least one case where a couple I know has been trying to adopt a child from Russia. And this has been going on for years now.
Yes.
The child, when they first saw her, was just a tiny little, really an infant or a toddler. Now has gotten to the point where she's quite a bit older than that, and it's still going on, and it's very difficult in those situations. I would imagine the complication of international law adds to that. But what are you seeing right now in terms of adoption law? Is it becoming easier, more difficult? What are the kinds of problems that you're seeing these days?
I will say international adoption certainly is the most difficult. You have to adopt the child under the laws of whatever country the child is coming from, and those change, of course, from country to country. And then you have the INS to deal with, bringing the child into this country. And once the child gets here, then you domesticate the adoption here, which means that you take it into a court, and the court gives this foreign adoption full faith and credit, recognizes it as an adoption here in the United States, and they are the most difficult, take the longest amount of time. Most countries require that the adoptive parent actually go to that country, spend some time there, sometimes as short as 2 weeks or something like that, but they are expensive and take a long period of time. The second type of adoption is what we call a private adoption, where perhaps the neighbor girl is having a child and she wants to put that child up for adoption. Those adoptions would take, I would say, about 6 months from beginning to end. So they are second longest and also second most expensive. Yeah. In that situation, the birth mother can request that the adoptive parents pay up to $3,000 of her living expenses and her medical expenses. That is not reimbursable if the birth mother changes her mind. You have to get a home study. Sometimes, depending on where you get those can cost up to $1,500. Then the third type of adoption, which we see a lot of, thank goodness, is the foster child adoption. Those are the quickest, cheapest. There's actual federal monies that's available to assist people to adopt foster children, to get them out of the system. And those can occur now. We're seeing them happen in as quick as 2 months.
Wow.
So that's real good.
And do they tend to be older children as opposed to?
Not necessarily. Not necessarily. We see a lot of, I mean, you think of your abuse and neglect cases and in the situations where children are removed from the home. We see a lot of drug, cocaine addicted mothers, crack. Meth is huge in Elkhart County right now. But there's always the question about, the child and the damage that has been done. And I just say, thank goodness there's a lot of people that are willing to take that on and rescue the child. And then lastly is a step-parent adoption, where mother or father, custodial parent has remarried, and that person wants to adopt.
And that's usually a bit more straightforward, I would assume.
It is.
Okay. On the line with us now, Dennis in Elkhart, and asking about what age child support ends. Dennis, good evening. Go ahead with your question.
At what age does child support end? Under what conditions?
All right, Bev, let's go there. And there's a straightforward question: Is there such a thing as an age at which child support ends?
Yes, there is. In law school, one of my law professors said that the answer, you'll spend 3 years, X amount of dollars to learn the answer to everything is it depends. And so no straightforward answer, but 21, unless the child is emancipated prior to that date. Emancipation can be done 2 ways. One, the criteria that has to be met is that the child is 18, has been out of school for at least 4 months, and is capable of supporting themselves. Doesn't mean they actually are, but they're capable. Judges look at whether they have a job, whether they have health insurance, etc. Secondly, the other prong, if you will, is whether or not they're under the custody and control of either parent. And if you proceed under that part of the statute, they don't necessarily have to be 18. They don't necessarily have to be out of school for 4 months. We see that sometimes if a child under 18 gets married, all kinds of different scenarios.
Yeah, and the question seems to be aimed at what's the earliest that child support could end. You mentioned 21. Is that an end-all? So that or are there circumstances that take you beyond that?
Well, if a petition is filed prior to the child reaching the age of 21, what can extend past 21 is college expenses. Okay.
All right.
So that's a little different than support, calculated differently.
All right. So again, the answer is it depends.
It depends. 21 by operation of law. You don't need to do anything if the child turns 21. Support ends.
All right.
But it can end earlier by emancipation.
All right. We're going to try to get one last question on here. Joan is on the line from South Bend. Joan, go ahead with your question, and good evening.
Yes, my question is about a will. My mother died when she was 91. She owned her own home. We sold the home for $57,000. That money was turned over to the attorney. The problem is, in these 7 years, he's never closed the account. I keep calling about every 3 or 4 months. He's always very pleasant with me, always very kind, and he's always going to do it later, but it never happens. He's very popular in the city that he lives in. His family's well known. I called another lawyer to see if he would help me. And basically, he told me that there wasn't any lawyer in a radius of 25 miles that would help me because this lawyer is very popular.
All right.
What can I do?
Joan, it's a good question, and I don't know if there's a specific answer on that one, but it sounds like you may have a complaint against the lawyer himself. Go ahead. Who would like to jump into that one? Todd?
I've got a little experience in the matters of probate, but there are a couple of questions that immediately jump to mind. The first is why won't it be closed?
Why hasn't it been closed in 7 years?
Why hasn't it?
Yeah.
There's a problem somewhere. Now, it could be the attorney's fault. It may be a problem with the court. It may be a problem with the estate itself. There may be claims out there. There may be litigation related to her passing that has not been resolved, and you can't close the estate until then. It's virtually impossible to know why that hasn't been closed without actually looking at the file.
Exactly. Generally speaking, if there is a complaint against an attorney, though, how do you go about doing that? Who do you file that with? Where do you go?
Attorneys have an obligation to report disciplinary matters to the Supreme Court Disciplinary Commission. Individuals can also do so that way. Some local bars may have their own local disciplinary branches that you could report them to. Typically, the first or most likely step would be going to the Supreme Court Disciplinary Commission.
All right. Well, at least that gives us a direction to go. Thanks all of you for being here tonight. We appreciate it. Unfortunately, we've run out of time. It's all the time we have for tonight. If you have any other questions, though, please seek the appropriate legal representative for your individual circumstances, and you heard us say that a lot tonight. Remember to join us again next week as we welcome medical experts to discuss colon cancer. And we thank you for joining us tonight. We hope you join us again next week on Ask an Expert. I'm Gary Sieber. Have a great evening. We'll see you next week.
This WNIT local production has been made possible in part by viewers like you. Thank you.